The courtroom drama surrounding Nnamdi Kanu has taken yet another dramatic turn. For years, the embattled leader of the indigenous people of Biafra has been at the center of Nigeria's most controversial legal marathon. But on 26th of September 2025, the Federal High Court in Abuja handed down a ruling that could reshape the entire trajectory of this case. Justice James Omotosho dismissed Kanu's no-case submission, a move that has compelled him to enter his defense against terrorism and treasonable felony charges brought by the federal government. But beyond the legal jargon, this decision raises burning questions. What does this mean for Nnamdi Kanu's fate? How prepared are his lawyers to take on the full weight of his trial? And could politics, not just law, ultimately decide how the story ends? Now let's break it down. But before we do, welcome to Political Arena, a place where we get to dive into in-depth analysis on political matters. So do well to like, subscribe, share, and be a part of the conversation in the comments. On 26th of September 2025, Justice James Omotosho delivered a crucial ruling. He stated clearly that the Department of State Services, the DSS, had presented enough evidence through 5 key witnesses to establish what lawyers call a prima facie case. In simple terms, this means that the evidence presented before the court cannot be swept aside. Kanu must now step forward, take the stand, and explain his side. The judge emphasized, however, that this does not amount to a declaration of guilt. Kanu remains innocent until proven otherwise. The prosecution still carries the heavy responsibility of proving its case beyond reasonable doubt. But Justice Omotosho was firm. Based on the testimonies already heard, Kanu has a case to answer. He further dismissed claims by Kanu's team that he was illegally renditioned into Nigeria. According to the court, no substantial evidence was produced on that front. So what does this mean? It means the no-case submission, which was supposed to be a lifeline, a shortcut to freedom, has collapsed. The legal marathon continues. But this legal drama is not unfolding in isolation. It is happening against the backdrop of a fierce battle over Kanu's health. Conflicting medical reports have thrown the court into a dilemma. On one side, the DSS medical team insists they can handle his condition within their facilities. On the other side, Kanu's private consultants, led by Professor Martin Agabi, claim his health is deteriorating dangerously and recommend urgent transfer to the national hospital or even treatment abroad. To resolve this, Justice Omotosho made an unusual but significant move. He ordered the Nigerian Medical Association NMA to step in within 8 days. The NMA must assemble a panel of 8 to 10 top medical experts, including a cardiologist, a neurologist, and the chief medical director of the national hospital. What is their task? To determine whether DSS facilities can indeed handle Kanu's health needs or whether a transfer is necessary. This is more than a medical issue. It is a matter of survival. As Kanu's lead counsel, Dr. Onyechi Bazu argued, it is in the interest of justice that he remains alive to face trial. Now here comes the crucial point. How prepared are Kanu's lawyers for the real battle ahead? Several times, one of his lawyers, Aloy Ejimako, has raised alarm that the DSS has restricted full and private access to their client. Without unrestricted access, how can the defense strategize effectively? How can they prepare for cross-examination, witness rebuttals, or even build the narrative of innocence that Kanu so desperately needs? Legal analysts believe this could have a major impact on the fairness and transparency of the trial. After all, a strong defense requires communication and some level of confidentiality. If those channels are blocked, then the scales of justice risk tilting dangerously. But beyond the courtroom, there's another theater where this case is being played out, the political arena. Abia State Governor Alex Otti, in a media chat recently, revealed that he and other Southeast governors are already in talks with the federal government to seek a political resolution to Kanu's case. This is huge because no matter what happens in the courtroom, history has shown us that some cases in Nigeria are ultimately resolved not by gavel but by politics. The questions, therefore, are: will the federal government be willing to strike such a deal? Or will the legal process drag on until 2027 elections become the next battleground for this issue? For Kanu himself, this ruling means more delays, more uncertainty, and possibly more time in DSS custody. His fate is no longer hanging by just a legal thread, but also by the strength of his health. For his lawyers, it's a wake-up call. They must now prepare to defend him fully in open court, counter the prosecution's witnesses, and mount convincing case of innocence. For the Nigerian justice system, the trial will test whether the courts can balance national security concerns with the fundamental right to a fair hearing. For the Southeast, the case remains a flashpoint of tension. If handled poorly, it could deepen political and social unrest. If resolved politically, it could ease years of political agitation. So, as Nnamdi Kanu prepares to take the stand and defend himself, the stakes couldn't be higher. His strength, his health, and perhaps even the political stability of the Southeast all hang in the balance. The next court date is October 8. All eyes will be on Justice Omotosho's court. But make no mistake, what happens there will ripple far beyond the courtroom. Will justice prevail? Will politics intervene? Or will this legal marathon drag on endlessly with no finish line in sight? Here on Political Arena, we will keep asking the tough questions and giving you the analysis you won't hear anywhere else. Do well to join the conversations in the comments. See you in the next one.